In the absence of any rational basis, what remains of proponent's case is an inference amply supported by evidence in the record that Proposition 8 was premised on the belief that same-sex couples simply are not as good as opposite-sex couples. Whether that belief is based on moral disapproval of homosexuality, animus towards gays and lesbians, or simply a belief that relationship between a man and a woman is inherently better than a relationship between two men or two women, this belief is not a proper basis upon which to legislate. The Constitution cannot control private biases, but neither can it tolerate them. The evidence shows that Proposition 8 was a hard-fought campaign and that the majority of California voters supported the initiative. See background to Proposition 8 above. The arguments surrounding Proposition 8 raise a question similar to that addressed in Lawrence when the court asked whether a majority of citizens could use the power of the state to enforce profound and deep convictions accepted as ethical and moral principles through the criminal code. The question here is whether California voters can enforce those same principles through regulation of marriage licenses. They cannot. California's obligation is to treat its citizens equally, not to mandate its own moral code. Moral disapproval without any other asserted state interest has never been a rational basis for legislation. Tradition alone cannot support legislation. Proponents' purported rationales are nothing more than post hoc justifications. While the Equal Protection Clause does not prohibit post hoc rationales, they must connect to the classification drawn. Here, the purported state interests fit so poorly with Proposition 8 that they are irrational, as explained above. What is left is the evidence that Proposition 8 enacts a moral view that there is something, quote, wrong with homosexual couples. The evidence at trial regarding the campaign to pass Proposition 8 uncloaks the most likely explanation for its passage, a desire to advance the belief that opposite-sex couples are morally superior to same-sex couples. The campaign relied heavily on negative stereotypes about gays and lesbians and focused on protecting children from inchoate threats vaguely associated with gays and lesbians. At trial, proponents' counsel attempted through cross-examination to show that the campaign wanted to protect children from learning about same-sex marriage in school. But the fact is that what the Yes on 8 campaign was pointing at is that kids would be taught about same-sex relationships in first and second grade. Isn't that a fact? That's what they were referring to? Quote from the trial. The evidence shows, however, that Proposition 8 played on the fear that exposure to homosexuality would turn children into homosexuals, and that parents should dread having children who were not heterosexual. The testimony of George Chauncey places the Protect Marriage campaign advertisements in historical context as echoing messages from previous campaigns to enact legal measures to disadvantage gays and lesbians. The Protect Marriage campaign advertisements ensured California voters had these previous fear-inducing messages in mind. The evidence at trial shows those fears to be completely unfounded. Moral disapproval alone is an improper basis on which to deny rights to gay men and lesbians. The evidence shows conclusively that Proposition 8 enacts without reason a private moral view that same-sex couples are inferior to opposite-sex couples. Laws of the kind now before us raise the inevitable inference that the disadvantage imposed is born of animosity towards the class of the persons affected. Because Proposition 8 disadvantages gays and lesbians without any rational justification, Proposition 8 violates the Equal Protection Clause of the 14th Amendment. Proposition 8 fails to advance any rational basis in singling out gay men and lesbians for denial of a marriage license. Indeed, the evidence shows Proposition 8 does nothing more than enshrine in the California Constitution the notion that opposite-sex couples are superior to same-sex couples. Because California has no interest in discriminating against gay men and lesbians, and because Proposition 8 prevents California from fulfilling its constitutional obligation to provide marriages on an equal basis, the court concludes that Proposition 8 is unconstitutional.